Hi, I'm Jeremy Love, immigration attorney and the founder of the Love Law Firm. We focus specifically on immigration cases and located here in Hoover, Alabama. It's a pleasure to talk to you today about the exciting announcement yesterday that the Obama administration made regarding the expansion of provisional waivers that's set to go into effect on August 29th. Apologize for being a few minutes late today. Had to change venues because they were literally chainsawing the trees outside of the other room that I was in. But anyway, it's a pleasure to be here. I'm going to talk a little bit about the change that was announced yesterday, something that's been talked about for over a year, but it's finally here, so we're excited about that. And I'll talk about how this fits in with the rest of the family-based process, and then try to answer a few questions before summing everything up. So feel free, I'm going to try to check while I'm talking if we have any questions. So feel free to send it to me. If not, I'll try to answer questions on Facebook directly, anybody who adds a note on there. So the change that was announced yesterday, well, previously only an applicant who has a U.S. citizen parent or spouse could file for a provisional waiver. Now, the provisional waiver went into effect in 2013. There existed a waiver previous to that, but it had to be done outside of the U.S. So the announcement is that the waiver will be available as of August 29th to someone who has a legal permanent resident spouse or parent. Now, part of that process involves showing extreme hardship on the citizen or permanent resident, which is a complicated thing to do, but I'll discuss that in a little bit. So it's a big deal because it definitely opens up the waiver possibility to a lot more people. So to talk a little bit about the general family-based process, I want to mention first that there are some people who don't need waivers. For example, if someone entered the U.S. with a visa and has an immediate relative U.S. citizen, now according to immigration, your immediate relative is a spouse, a minor child, or your spouse or minor child. And also a parent, if you're filing for your parent and you're at least 21 years of age. So those are the immediate relatives as far as U.S. immigration is concerned. And anyone who entered with a visa has immediate relative U.S. citizen. They do not need to file a waiver if they entered with a visa. So this does not apply to those people. Who does this apply to? Well, this change in general, anyone who needs a waiver is someone who entered the U.S. Without a visa or is not the immediate relative of a U.S. citizen. So the first step in the family petition process, or family-based process, is the petition. So a U.S. citizen can file for several people, can file for different people than a permanent resident can file for. Who can a U.S. citizen petition for? A U.S. citizen can petition for their spouse, children, and if they're over 21, they can also petition for their parents or siblings. Now, a permanent resident can file a petition for spouses and unmarried children. A permanent resident cannot file for their siblings, for their parents, or for married children. So that's a big difference. One of the benefits of being a U.S. citizen is that you can file a petition, an I-130 family petition, for more people. So that's something that's important. That has not changed. That's still the same. But if the applicant, for example, is not a spouse, parent, or minor child of a U.S. citizen, for example, if it's a spouse of a permanent resident, there are waiting periods, and that after the petition is filed, before someone can continue with the process to become a permanent resident. So, and the waiting periods depend on the relationship, the country of origin, and there's a visa bulletin. I can go into more detail on this, but it changes every month. It's a little bit complicated. So, we'll let you know that in certain cases there are waiting periods after the I-130 is filed before you can go with the next step, which is the consular process and waiver. Again, my name is Jeremy Love, immigration attorney here in Hoover, Alabama. And we're speaking in English right now about the change announced yesterday on the provisional waiver. In a minute, I'm going to do another video in Spanish. Hola, me llamo Jeremy Love, soy abogado de inmigración. En este momento estamos hablando del cambio anuncio ayer del presidente Obama sobre la expansión del perdón provisional. Después de este video voy a empezar de nuevo en español. So after the waiting period's over, or for immediate relatives, there's no waiting period of U.S. citizens. Then the consular process and waiver part begins. That involves paying some fee bills, filing applications with the National Visa Center, and mailing a list of documents, as well as filing the waiver. And in order to obtain the waiver, you have to show extreme hardship on that U.S. citizen or permanent resident family member. Now, again, waivers are only available to applicants who have spouses or parents who are U.S. citizens, and as of August 29th, people who have parents or spouses who are legal permanent residents. So I just want to mention that. Previously, before 2013, that waiver was done in the country of origin, and I didn't recommend it much back then because if your waiver was denied, you were outside the U.S., you had to wait several months already, and if you're denied, you're stuck wherever you are. So in 2013, they initiated the provisional waiver that allowed people to file for the waiver here in the U.S. before leaving for the consular interview and medical exam that they do. So after 2013, March 2013, the process abroad was much quicker, a couple weeks, and that was it, and then you're back. And also a lot less risky, because if your waiver is denied, since 2013, you're here in the U.S. When they deny it, so you just don't leave for the interview abroad, and you're in the same situation you were before, but at least you're in the U.S. and still with your family. So that's telling you a little about the waiver process. In order to show that extreme hardship, there's a number of things that you include. There's a lot of documentation that goes into this. It's a complicated process, and a lot of it depends on the officer, but you have to be prepared with an argument that documents all of the things that you're trying to show as far as hardship goes. That includes financial hardship, medical hardship, educational, and also significant ties to the U.S. So it's not just wanting to be together. You have to show more than that. It's not just finances. You have to show more than that. There's a lot you have to show in order to obtain an unlawful presence waiver based on extreme hardship. The other thing I want to mention about the waiver is this is only a waiver for unlawful presence. Only unlawful presence waiver can be done stateside. Waivers for other types of issues, for example, criminal issues, those are still done abroad. That hasn't changed. What I'm talking about now is an I-601A waiver, which is done in the U.S. I-601 waivers are done outside the U.S., just to clarify that. So then once the waiver is approved at the consulate, this is the 601A waiver, the 601A waiver, once it's approved here, you go to the interview in your country of origin, do the medical exam, wait a little bit of time before you receive an immigrant visa that's in your passport, allows you to enter the U.S. You're outside the U.S. maybe 2 weeks or so. It's an estimate. Sometimes things come up, but that's generally a good idea. And then when you come to the U.S., there's another form that needs to be filed, another bill that has to be paid, and then immigration mails your green card to your address here in the U.S. So that's the process in general. Just to sum up, the stateside waiver for unlawful presence is now available to applicants whose parents or spouses are U.S. citizens, and will be available next month to applicants whose parents or spouses are legal permanent residents. So it's a big change. I had a conversation with a potential client last week who's had issues with the naturalization exam. She hasn't been a permanent resident for 15 years, so she's not eligible to waive the English requirement. So this would help her out a lot because she wants to file for she's filed a petition for her spouse, but he can't get a waiver right now because she's a permanent resident. Now, as of August 29th, he will be able to get a waiver by virtue of being married to a permanent resident once this change goes into effect. Just checking to see if I have any questions right now. Sometimes Facebook's a little bit slow in getting questions while we're live, so I'll see if anything comes up. Again, I'm not in my regular office because they're cutting down trees outside my office apparently. But anyway, here we go. I haven't seen many questions. One question I received was who can file for a sibling. That's still the same. That hasn't changed. U.S. citizens can file petitions for siblings. Now the issue is that a sibling, if let's say you're an applicant, you need a waiver, and your sibling's a U.S. citizen, there's not a waiver available for that. You have to have a spouse or parent who's a U.S. citizen or permanent resident. That's something I wanted to clarify. But anyway, I hope I was able to explain the provisional waivers. Feel free to reach out to me with any questions you may have. The information on our website we haven't updated since the change, so it just mentions U.S. citizens, although there's an article on there we wrote that goes into the proposed changes that were made a year ago. So that goes into the info that we have now, so it's pretty accurate. Go to jlovelaw.com, and if you click on immigration, you can go down and see provisional waiver, and there's some information in there and a link to the article. That's what I recommend. But I want to say thank you again for joining me today. I hope I was able to explain the information clearly and thoroughly and keep it short for you. Please remember that waivers are very complicated and every case is different. Please consult with an immigration attorney who has experience in family-based waivers regarding the specifics of your case. And you deserve nothing less than that, than have someone who has that experience and is able to evaluate your case specifically. Thank you again, and I hope you have a great day. And please feel free to reach out to me at jlovelaw.com or 205-323-8727. That's our phone number. Thank you very much.